Welcome everyone to the IAPP web conference, Privacy Beyond Checkmarks, How to Navigate Cross-Border Transfers, sponsored today by Security. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the name registrants with 1 CPE credit. I also want to let you know that a recording of this program will be available in your MyAPP portal under your My Purchases. If you just click on the title of the web conference, you'll see the recording of the video there and then the slides as well within about 48 hours. Please feel free to post any questions you have for the panelists in the Q&A area specifically at the bottom of the screen. And we're hoping to get to a couple of those at the end of the program. Now onto our program. I'd like to introduce today's moderator, Rehan Jalil, CEO of Security. Thank you all so much.
Jordan, thank you so very much. I'm so excited to actually do this panel. It's such an important topic of the day. I'm going to share my screen also while we go through this panel. So yeah, I think we're living in this big bang era of data, right? There is a massive growth of data, and data is going, in all kinds of clouds and SaaS services, and you really have to understand exactly where the data is going to different parts of the world. That's itself the growth of the data and its expansion across the globe. In addition, of course, we more and more, this global workforce, remote work, and people are actually across the globe who can access this data. In addition, of course, we know there is a growing regulatory frameworks across different parts of the planet, and there's ever-evolving landscape of regulations on the data sovereignty and cross-border laws that are coming up. And this is a very dynamic environment where you actually have to understand not only where the data is, where the people can access it from, what the laws are. And old days of just getting some kind of an assessment done on it, getting some check mark, is just not sufficient, because this is such a fast-moving kind of environment. So in that kind of a landscape, there has to be not only good understanding of the law, but a good way to monitor the data, where it is sitting, where is it moving, and who is accessing it, and how do you do that at any given time and understand that you're actually being responsible with the data sovereignty and cross-border laws. And we've seen this recently, even in the media, all kinds of very political topics that are kind of revolving around it. I couldn't be more excited that we actually have a very strong set of panelists who are here to actually tell us how they see and how they actually implementing in their own environment the controls that need to be put in place so that cross-border and data sovereignty laws are being honored. So with that, I'll make the introductions. We have Jason Elbert. Jason, raise your hand. You'll actually see probably the coolest panelist. I mean, he's some amazing place, and it'll be a lot of fun. Jason, thank you so much for joining. We have Andy Shi from Hertz. Andy, I think Andy is right there. And we also have Joe from IAPP, and Nicole from Baker Holstetter. And also we have Sandeep from AWS. So thank you so very much for being on the panel. I think maybe we should start with actually understanding of the law itself. And because it's a topic that's kind of evolving. So maybe first question I'll actually ask the panelists is that, what are some of the key regulation requirements that organizations keep in mind? Some things that is kind of more recent and more evolving. And I think maybe I'll pass it on to Joe to give you a view of the current regulatory landscape around this topic.
Thanks very much, Rehan. It's great to be on this panel. So in terms of the regulatory landscape, I'll start with Europe. And not just because I'm physically based in Europe, because a lot of what we're seeing happen around the world has its origins in European data privacy law. And here in Europe and in the EU specifically, there's essentially a de facto prohibition on transferring data internationally, unless you put in place a regulatory compliance mechanism, or there is a lawful data transfer mechanism in place. Some of those mechanisms are very well known. Data adequacy is one that often hits the headlines for privacy professionals, in part because of EU-U.S. negotiations. That is arguably the most straightforward mechanism. It's essentially a whitelisting of jurisdictions that meet the EU's data privacy test. There are other mechanisms. Some are put in place contractually between a data exporter and a data importer. And there are various derogations and exemptions. Consent is one example that you can rely on for data transfers. So there are various modalities through which you can lawfully transfer data outside of Europe to a third country jurisdiction. That model has essentially been proliferating around the world. The UK, as a consequence of Brexit, has a very similar regime, so too does Switzerland. But as you look beyond Europe, there are many other countries around the world that have very similar regulatory provisions. They start from the position of prohibiting data transfers unless or until there is a lawful mechanism in place. We have seen some movement towards the design and delivery of these mechanisms over the past few years. There's adequacy decisions between the EU and South Korea, EU and Japan. There is a draft adequacy decision between the EU and the US. I know we'll talk about that later, but we have also seen some turbulence in this space and some disruption. So of the two EU-US adequacy decisions we've seen in place, both of which have fallen foul of the Court of Justice. The Court of Justice of the EU has struck them down, found them inadequate. And so therefore we are where we are today, which is where the EU and the US are negotiating in the final stages in the 11th hour of trying to put in place a new mechanism. So that's the European approach. As I say, it's proliferated around the world. Other countries, it's important to say, other countries take quite different approaches. The United States does not have that starting position of restricting data transfers. There are various other rules around consumer protections in the FTC Act around trust and the consumer rights. China has a similar but different approach. Their contractual clauses are much more important. They are much more complex as well. And we are seeing more regional and multilateral and plurilateral approaches to bring this together. So that's kind of a 101 on the regulatory approach.
Joe, thank you so very much. Nicole, I'm sure you get a lot of questions based on your expertise. It'll be great to actually hear from you. What are top of mind topics that you get a lot of questions about?
Sure. So I think sort of picking up on where Joe just left off as well, we see this sort of types of localization really kind of falling into buckets. These ones where you really need to keep data in country, ones where you can move data out of country but need to keep a copy in country, and then these others that kind of fall under the EU model of having standards that you can meet in order to move the data, or permission potentially that you need to seek, for instance, permission of a regulator. So those are kind of the four buckets that you're dealing with. And then I think we deal with a lot of questions too around onward transfers. So for instance, in the scope of Europe, you could move, for instance, your data from France to Canada, but then what happens when you move it from Canada to the US or Japan to the US? And just being able to track that data, to know that there's even EU data and data that you might potentially be getting from another country is where a lot of times we're trying to answer questions and trying to get the right answers to be able to scope that. And then I think the other piece that we really run into with a lot of the laws is whether they're applicable or not, because the scope of territoriality and things like that can vary quite drastically across a number of them. So some of them are only applicable if you're processing in country or if you have an establishment in country. Others are applicable if you have some sort of a link to the country. For instance, you're offering goods or services, you're monitoring the individuals, the sort of European approach there. Some of them cover if you've agreed to a contract that puts you within scope of the law. And then others are as broad as saying that you collected the data from a particular country, or that it's collected from people within that country, residents of the country, or even citizens of the country. And if you're collecting under a broad label of citizenship, does that then follow people all over the place? So it gets very complex to try to figure out what types of data you have in your flows and what laws they might be subject to. So parsing that out, I feel like, is a lot of what we're trying to do right now to make sure that people are as compliant as possible when you're moving these types of data in. And I would also just mention that in terms of, so there are a lot of restrictions, for instance, around public sector data, private sector data, where we see restrictions in particular around localization, health data, financial data, business records, and then I would also say telecoms, probably the four big areas where we see a lot of restrictions on those, and they don't always fall neatly within what we think of as your sort of comprehensive privacy laws. A lot of them are under other types of laws that might come into play. So just a lot to kind of keep track of, and I think that's probably the biggest questions that a lot of companies that are trying to operate in more than one country are dealing with.
Well, talking about that, ADP, a global company, like data is everywhere. In addition to the regulatory framework which we have to honor, I'm sure there's some, companies' internal policies, internal desire to how they control the data, being more responsible. Maybe go one step beyond just what regulation is asking for. Jason, it'll be great to hear from you, especially from the lens of ADP. Like, what are the other things that could be that beyond just the regulatory framework that you would have to deal with, and how do you actually put that in place?
Well, that's a great question, Rehan, because we are operating in more than 140 countries, providing human capital management and payroll services to our clients, and so we need to be able to comply with laws. We need to enable our clients to meet their regulatory obligations, and even beyond that, right? Clients entrust us with some of their most sensitive data, information about their employees, about who they have and what they're paying them and how they manage them, and so they're going to want that information protected, even in the absence of laws. And so what we've done at ADP is we built comprehensive privacy programs. We started actually with a foundation based on data transfers, right? We have our approved set of binding corporate rules. We actually have 3 sets. We have binding corporate rules as a data processor to be able to, receive data, European data from our clients, and then, transfer it to ADP offices. And then we have 2 sets as a controller, one for our business contact data and one for our own internal associates or our employees. And we've used those binding corporate rules as a basis to build a comprehensive privacy programs. And then we tweaked those based on regulatory requirements. So we had, our EU program, and then we have the U.S. program that we've just done a revamp of in light of the new law in California, CPRA. We have programs in Latin America. We're doing work in Canada. And all these programs are common in the sense that they all focus on the same sort of things. Do we have permissible purpose to process the data? How do we control access to the data? How do we enable clients to meet their individual rights request obligations? How do we purge data when it's no longer needed? And then, they're tweaked for the particular requirements about notice and other things that you have to give employees. And then beyond that, we obviously try to help our clients by providing them information. We issued them, updates on regulations. We tell them you may want to think about this or that. Right now in China, with the new model contracts, we're reaching out to companies to say, we need to think about getting these in place. So overall, what we've done is we've taken the regulatory framework actually around data transfers and our binding corporate rules, which are a detailed set of requirements that we have gotten approved by the EU regulators, and then use those to build a global privacy program to help meet those various requirements.
Jason, thank you so much. Seems like an environment certainly requiring a lot of understanding of the law, but also a lot of automation to understand the data and the movement and the access and all. And we're glad that we actually have all the major companies here have a very strong global presence. So I'm sure they have a strong view. Sandeep, AWS, very global. What's your thoughts on that?
Yeah. So thanks for having me as part of the panel. We sort of have a very unique perspective, and my role specifically with working with the global financial institutes sort of lends itself to these complex challenges that Jason is talking, that others have started discussing. Customers, when they move to AWS, to a cloud provider, they're seeking explicit guidance that's not, it's all interpretation, it's all still being worked on. And our role as compliance specialists or compliance organizations supporting customers is how do they think about a global workload that's sitting within their data centers, as an example, when they start to think about that in a cloud-based deployment, what are their obligations as a customer in terms of where the data needs to reside? And some of that is just introducing a lot of complexity, which, if we think about cloud deployment and we're starting to think about innovation and doing things more simply, if there are jurisdictional requirements that they have to meet for that global workload that has EU data and EU countries data and it has US data, or has APAC specific countries. APAC we think of APAC as a region, but really it's 17, 18, 20 different countries that have specific laws on the book appropriate for their country. And in each of those cases, if there is a localization requirement or data cannot leave the boundary or X data cannot leave the boundary, our role is to really help the customers in navigating those requirements, because the last thing these institutes want is to be on Wall Street Journal or a reputational risk as they're continuing their journey to cloud enablement. So our role is unique, and we really help customers see sort of how they can continue to do these deployments, migrations in a compliant manner.
That's awesome. I think a quick message to the attendees that if you have any questions, please feel free to type it in the Q&A section. I think between this discussion, some of the panelists may be able to answer the question in real time, and we will definitely leave some room towards the end. And if you can't get to all the questions, we'll try to reach out and we try to address those questions. So please, making this interactive is going to be a lot more fun.
Sorry, Rehan, just to jump in, I noticed that we got one question that might be useful to level set on before we move on, and it's the question: what is considered a transfer of data, or what does a transfer mean, and does that include access, and is there a sort of common definition? I think that the definition varies somewhat. Clearly, access is part of a transfer in accordance with what the EU standards are at this point, and I would say, to the extent that you're looking for a common definition that can be used globally, including access as part of transfer, is probably the safest route to go there, or the one that would probably hit the most. I don't know if anybody else wants to add to that.
Yeah, look, I would just totally agree with that. And the EDPB, so the group of European data privacy regulators, issued some guidance early this month, late last month, on what exactly that question: what is a transfer? I mean, specifically, they were looking at what is a transfer in the context of the GDPR having extraterritorial application. So there will be scenarios where one entity is covered by the GDPR in multiple countries outside of Europe. And in what circumstances is it necessary to put in place a data transfer mechanism, even though you're already covered by the GDPR? So there are various helpful use cases and case studies where the EDPB essentially says covered or not covered by the GDPR and covered or not covered by the data transfer requirements.
Awesome. It's great to make it interactive. Thanks, Nicole. Thanks, Joe. So for that reason, for more reason, the panelists actually provide value to you, the attendees. So keep the questions flowing. We will pick those up. Some will be just answered on the side panel. So, okay, now we understand a bit like, okay, this is a complex regulatory landscape. Now within an organization, and you're all part of some of the biggest organizations on the planet, how do you prepare yourself for these requirements? How do you scope the program or understand even the data footprint and what is the right course of action to actually take? Understand the access patterns that may be going on in this data. How do you put this plan and put that to action? It'll be great to actually talk about it. And Jason, I think you alluded to especially the kind of footprint that your organization has. It'll be great to actually hear from you how you put this actually programming in place.
Yeah, so obviously what we do is we have privacy stewards that are embedded in each of our business units, and so they really understand their business, the client base, the product offerings, and then we try to understand, all right, where are you doing business? Because some of our products, right, are designed for use in some countries, but people may put data from other countries in them. So what is the footprint there? And then what do you need to be in scope for their program? And then for each program, we have a set of requirements. Like you have to, have done training of people who might get data access requests in California. You have to have a process for, responding to IRR requests that come from clients. And then what we do is we make sure that the progress is put in place. We make sure that it's documented, that, it then goes through a set of approvals so that it meets the obligations of the program, and so it meets the legal obligations. And then we go through every year and we do a compliance check-in or test or attestation process. All right, do you still have these in place? How do you feel you are in relation to these? Are there any things we need to look at so that, compliance is not a one-time activity? And then, so that's how we operationalize it from the privacy side. And then, of course, now we're working with our chief data office on some increased automation of data detection. All right, what data do we have? Where is it? How does it flow? How do we see a person's data across different aspects? And so that will allow us to perhaps automate more our response to IRRs, help us understand data flows better. And of course, there are various tools that can be used for that. But obviously, Rehan, the tool that your company provides, security, is one that really helps with us. And I think it's always going to be those combination things. It's going to be a combination of some automated discovery, so you don't miss things, and then working with people who understand the business and make sure that the business drives compliance, as opposed to it being just from some external office.